Please rise. The Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard. You be seated.
Good afternoon. Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have some 4 hours of argument that have been requested today, so please bear that in mind as I call the calendar. Understand that we have your briefs, we have the record, so we're fully familiar with the facts of your cases. So just please ask only for the time that you'll absolutely need to make your most important arguments. Okay? People versus Douglas Bates. 5, 1, and 5. Thank you. 67-69 St. Nicholas Avenue versus Green.
Appellant requests 5 and 2.
There's a submission, as far as I can see, by the respondent. Do you wish to submit as well?
I prefer not to submit unless the court directs.
Well, I won't direct you. I'll give you 2 minutes. I don't see that there are any questions.
2 minutes will be fine.
Okay, 2 and a submission. Krishna S. versus Claire A. Submitted. Chadha versus Wadena. Submitted. Moskovitz versus the State of New York. Submitted. ZL Infant versus Mount Sinai Hospital.
Appellate request 5 and 1, Your Honor.
5 and 1 and 6, thank you. People versus Frankly Lambe, submitted. People versus Corey Allen. Is there somebody else standing over there? Anyone here?
Just one side.
Okay, thank you. Okay. Looks like the panel is okay. We'll submit, thank you. Martinez versus the City of New York. Okay, you are the respondent?
Yes.
You want to argue against yourself here?
I just like 2 minutes.
Okay, up to you. Submission and 2 minutes. NYU University versus Turner Construction?
Appellant request 12 and 3. Respondent request 15, Your Honor.
6 and 2 and 6, thank you. People versus Michael Walker? 6, 2, and 6. Korn versus Korn. Submitted. Torres versus Sanitation Salvage.
Appellant request 3 and 1. Respondent request 2 minutes.
3, 1, and 2. Finkelstein versus Finkelstein. Submitted. First case is People versus Douglas Bates.
Good afternoon. My name is Elizabeth Vassley, and I represent appellant Mr. Douglas Bates. May it please the court. The prosecutor's 2 statements in summation, if you believe the police officers, then you must find the defendant guilty, were erroneous. The prosecutor
Or what? I'm sorry, I didn't hear you.
were erroneous, Your Honor.
Okay.
It was an error for them to make those statements in summation because the prosecution cannot burden shift or bolster their own argument by stating that if the jury believed 2 witnesses who were third-party witnesses who were not present for the entire encounter, that their testimony alone could prove guilt beyond a reasonable doubt.
Was all of that stated in the objection?
It was not, Your Honor.
Was the objection properly preserved?
It was preserved in that defense counsel contemporaneously objected to the improper comments.
With a one-word objection? Objection?
It was a one-word objection, Your Honor. This court has never explicitly held that a one-word objection is not sufficient for preservation, but
I agree.
counsel did provide the court with notice. The court could have taken the appropriate action. The court did not articulate its ruling, and as Your Honors are well aware, summation is, there's a flow to it, and often is not the type of proceeding where there's a lot of legal discussion. But regardless, this was prejudicial to Mr. Bates because the prosecutor said this 2 times, and eventually the jury acquitted Mr. Bates of the top count, where the elementary difference, one of the big elementary differences was unconsciousness. So it appears as if the jury did not believe the police officers, but they still convicted him of the other charge of forcible touching, and that could have been because of this improper statement and summation where they felt like they still, for some reason, had to convict him.
Well, they could have. That's true. That could be the reason. But there was also another aspect to it. It was for gratification or for, I don't know, not insulting, but degrading. So it could have been for that too, right? So it wasn't necessarily that they wouldn't have believed the police.
That's correct. Sexual contact does have those elements. Those weren't explicitly discussed as much as unconsciousness, which was very much the theme of the entire testimony. So it would make more sense that the jury would be referring to that element, given that there wasn't a lot of debate over degrading or for sexual gratification.
Well, if they did believe, whether it was, I think it was Preston who you said, or Plunkett, I can't remember, but if they did believe those officers, would the prosecutor have met its burden with regard to that?
They would not have met their burden because the officers did not testify that they saw the complainant asleep from the beginning. If they had said that they saw the complainant asleep, they saw Mr. Bates approach and then engage in this conduct, that would be very different. Instead, you have the police officers coming in mid-encounter without any information about what happened before, and that's why that wouldn't have met its burden, because there's a lot of questions. There's a lot of what ifs. What was going on in Mr. Bates's head? Did he understand that she was unconscious?
So you're speaking to the issue of the police alone without the victim, who also testified.
Yes, and that, because the police alone doesn't answer all of the other questions that could be posed by defense theories. Maybe Mr. Bates didn't realize all these different things. You could believe the police officers and still find Mr. Bates not guilty if you thought, for example, he wasn't aware of her consciousness or any consent was vitiated by unconsciousness and he wasn't aware of that. And because there isn't this full picture here, because the complainant didn't remember the facts prior, and because the police officers didn't come in until later, that statement in summation was error.
And I'm sorry, you said it was mentioned 2 other times, so 3 in total. Was there, I know there was 1 objection. Was there objection the other times?
It was only 2 times, Your Honor, and there was 1 objection that took place in the middle of those 2. And if there are no further questions,
Thank you.
I reserve my time for.
Good afternoon, Abigail Renard for the People. Briefly, just to clarify something from the record, my adversary commented that Mr. Bates's mindset was unclear. He very clearly, when he was interrupted by Officer Preston, responded immediately with, "It's okay, I know her, she won't press charges." One would think that if it was a truly consensual encounter and that he was unaware of what was going on, that would not have been his immediate response. However, it was, and that, when considered within the full context of all of the evidence that was presented, including the officer's testimony that when they came upon the victim and defendant, she was seated on the base of a statue, she was limp, unresponsive, her eyes were closed, she did not move or touch defendant of her own volition. Every time he tried to wrap her arms around his waist, they dropped back to the ground. The combination of all of these things and the totality of the circumstances indicated that and proved that defendant did not have her consent. And
Except that the objection wasn't to the totality of the circumstances. The objection was to the prosecutor's first stating the law, the burden of proof.
Correct, Your Honor, yes.
Which is not supposed to be done. And then following it by saying, and if you believe this officer, then you have to, we've met our burden of proof, or you have to acquit. I think that's what it was.
It was along those lines, yes, Your Honor.
And so it's really about that narrow objection, which usually there will be some statement that, you know, sustained as to speaking about the law and with regard to this particular witness or whatever it was. There was nothing. So.
Correct. Yeah, so the issue with the summation, first
Summation is, I think, what you.
So it was, the defendant's challenge is unpreserved because he only made one general objection, as Your Honor noted earlier, and.
So let me ask you about that one general,
aside,
with that one general objection. How, you know, there are times when a judge only wants the word objection said. I don't know that that was the rule here. Or wants the word objection with a one-word objection. I don't know if that was the rule here. But it was pretty clear that the prosecutor was reciting the law, which is supposed to be the judge's purview. So from that perspective alone, wouldn't have been, I mean, she's saying first he was misstating the law, and then he was shifting the burden by misstating the law and then talking about this, the officer's statement. So even if just one of those things was neither one is preserved?
No, they aren't preserved, but even preservation aside, Your Honor, the context of the statements indicate that the prosecutor was talking about a broader credibility argument that, you know, she started off by telling the jury, like discussing her very significant burden of proof and asking the jury to hold her to that burden. She then turned to discussing why each of the witnesses was credible. She first addressed the victim's credibility and explained how the victim helped establish all of the elements, and then she turned to the police officers, and she repeatedly, within the context of the disputed statements, used the word credibility. So when considered within the broader context, it's clear that she wasn't trying to argue that the officer's honesty or, you know, something of that nature alone was sufficient to compel a guilty verdict. She was just merely arguing that these are the elements that I'm required to prove, and if you find these witnesses credible, I have proven those elements to you. And even if she could have used better phrasing, you know, for example, using the word credible instead of believe, the court's instructions and her own instructions to the jury to listen to the court and to hold her to the burden of proof, and the court's instructions that it's the jury's job to determine a witness's truthfulness and accuracy, and that the attorney's arguments were just arguments for consideration and they had to follow the court instead of the attorneys. All of that would have ameliorated any potential prejudice, and ultimately any potential error here would have been harmless given defendant's the overwhelming proof of defendant's guilt. And if there are no further questions, we ask that you affirm.
Okay, thank you.
Thank you.
The statement in summation that if you believe the police officers, you must find the defendant guilty is wrong because it eliminates all that other doubt that is usually out there, where the jury considers the witnesses who testify, the witnesses who don't testify, the entire picture. And by making that evidentiary world just the police officers, the prosecutor improperly took away other doubt or other portions.
Why wasn't that a proper response to defense counsel's summation, which was that they must find defendant guilty if they credit the office testimony? Why wasn't that a proper response to that?
Because the prosecution is held to its burden, and the defense can argue that there's reasonable doubt, that things aren't met, but the prosecutor cannot then bolster its own witnesses and focus in on just their testimony. So we'd ask that you remand for a new trial.
Thank you, thank you both. 67-69 St. Nicholas Avenue against Green.
May it please the court, Carol Ann Herlihy for the appellant, 6769 St. Nicholas Avenue, HDFC. This is a low-income cooperative.
We're aware of the facts, so you have 2 minutes, get right to your
Yes.
point.
We're asking the court to allow the HDFC to have summary judgment. This is not a case that ought to be tried. There is no issue to be tried. And to put the HDFC through the burden of discovery and trial is unwarranted and particularly harsh given the nature of the appellant. As we noted in our brief, there was no reason to doubt the appellant's witness who said he was on the board at the time.
He sent an affidavit, and you're saying there was no evidence to contradict that, to say that he was there really 16 days ahead of time, or whatever the amount of time was before.
That was
So
a
it
pure,
stands alone.
if that were the court's notion, that possibly he was elected 16 days later than the lease, because his earliest piece of documentary evidence was 16 days later. If that were the court's basis, it is purely speculative. He affirmed that he was elected in February, as against the respondent's position, which was that he
You're saying there's nothing in the record to challenge his affidavit.
Yes, and furthermore, and maybe even more to the point, that even if you believed the respondent's version, this lease is no good. The respondent's version is she sat out and 2 other board members granted her and her husband a 99-year lease for $700 a month, which they proceeded to sublet for 3 and 4 times that amount. That's not a good lease. That is a waste of the corporate's asset that cannot be ratified. So there's no point to a trial.
Thank you. Let me see.
Thank you for
No
the
further
opportunity.
questions. Thank you.
Thank you.
ZL, an infant versus Mount Sinai Hospital.
May it please the court, my name is Dan Ratner. I'm from Heidel, Petoni, Murphy, and Bach. I'm representing the appellants on this appeal. The issue is whether summary judgment should have been granted in favor of my clients, largely because the plaintiff is alleging what is known as a preconception tort. The fact of the matter is that the prescription of the drugs that are at issue was made before the infant was conceived. The acts or omissions failing the prescription itself, any failure to warn, all of that occurred before the infant was conceived. So there's a bright line rule in this state under Albala, under Enright, and under multiple cases that are cited in my brief, holding that an act or omission that occurs before a baby is conceived is not actionable on behalf of the baby. Can't bring the lawsuit. Now, the mother might be able to, but the mother's not a plaintiff in this case. So it's really as simple as that. The second part of this is whether or not my client can be liable for anything that may or may not have happened after the baby was conceived. Now, there was a very, very short window, as the court is probably aware. The baby was conceived no later than January 30th, 2005. The prescription at issue, the last refill, occurred on February 8th. The neural tube defect that caused the infant to develop spina bifida was complete by February 27th, and the plaintiff did not appear at Mount Sinai Hospital again until March 8th, which means that by the time my client was aware that the mother was pregnant, it was already too late, unfortunately.
But when the mother appeared before the doctors, when she had her appointments, I think that they took tests, and she was not pregnant at either of the tests,
That's correct.
right? And the pregnancy, that what you said is that it doesn't happen until sometime in, I guess, January.
The latest date of pregnancy was January 30th, 2005. And the next time that the mother appeared at the hospital was March 8th, 2005. So by then, unfortunately, the neural tube defect had already developed. There's nothing that could be done at that point in time. The spina bifida was already going to happen. It's as simple as that. So there's a bright line rule in this state against preconception torts. And this idea that something may or may not could have been done after the baby was conceived is completely speculative. So unless the court has any questions, we ask the court to reverse and to grant summary judgment on all claims. Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court. Scott Horn, counsel representing the plaintiff respondent in this matter. It's our contention, Your Honors, that the motion court properly denied the defendant's motion for summary judgment because the plaintiff does
Let me
not.
ask you something in response to what opposing counsel said.
Yes, Your Honor.
When a malpractice claim accrues at the time of injury, how could the time of injury in this case be any time other than when the prescription was prescribed, that's what's caused the injury, which would be before conception, which would therefore the claim be barred by the line of cases?
Well, there's two parts to that question. First part is when we're talking about injury, we're talking about the injury to the fetus. So the injury to the fetus actually doesn't happen until conception, right? There's no injury to a fetus that doesn't exist prior to that.
To the malpractice to determine the time of accrual. How could the malpractice be any time other than when it was prescribed?
Well, there are numerous acts and omissions of malpractice that are alleged here. So one of the acts of malpractice, or I should say omissions, was the failure to monitor. So one thing that I listened for very carefully during the appellant's presentation was this concept of whether or not they monitored her pregnancy status, the mother's pregnancy status. There's no reference to that. That duty is ongoing, as established by the
You're
expert.
saying that they always had a duty to monitor for her pregnancy?
Only
Even though the last time they saw her, they had no idea that she would be pregnant sometime in the future.
The FDA black box warning specifically pegs the duty to warn to a person, a woman, of childbearing potential.
Has
So
she not
when you
been
give,
warned? Has she not been warned at Harlem Hospital that if she became pregnant, there was a risk to the fetus?
there's no evidence, Your Honor, of any warning that was issued to her in particular with reference to the defendants, but otherwise as well. She had a history of being treated with this particular VPA. These defendants increased the doses. They never provided the requisite warning that the FDA
Is there any
requires.
evidence whatsoever in the record that she ever told them, I'm planning to get pregnant, I'm thinking about getting pregnant, anything of that nature?
At page 1774 of the record, Your Honor, the defendant Pastore specifically and unequivocally acknowledged that she knew that the mother was sexually active.
Right, but
when
that's not my question. My question was about pregnancy. I mean, obviously, the drug is prescribed to people who are sexually active, and there's no malpractice involved in that.
That's not necessarily true, but even if
You
you
only
were to...
prescribe the drug to women who are not of childbearing age, otherwise it's contraindicated?
The expert opined that the failure to undertake a risk-benefit analysis with this particular mother who was known to be sexually active, the failure to prescribe folic acid along with the VPA, which reduces the risks by 50%, was a departure. The failure to...
In all the cases that the Court of Appeals determined, the injuries all occurred post-conception. So why is this case any different from those line of cases?
I'm sorry, Your Honor, I missed the first part of what you said.
In all the other cases, the Court of Appeals cases, Abala and Enright, the injuries all occurred post-conception. The child was injured post-conception.
That's correct, Your
Why
Honor.
is this case any different from that?
Because the negligence here, the actions and omissions in prescribing, failing to monitor, and failing to warn all continued throughout the entire period of the treatment. They issued a 4-month prescription knowing she was sexually active and knowing that spina bifida occurs within 28 days of conception.
So just, may I just, it goes back to the earlier questions about Harlem Hospital, et cetera, because you said that there's nowhere that Harlem Hospital had notified her. I see at the record, 971 and 1093 to 1094, it indicates that Harlem Hospital did counsel her about the need for birth control while she was on VPA, and she was given condoms and prescriptions for all oral contraceptions. Additionally, she even at one time indicated that she'd stopped taking the VPA independently on her own because she feared that she was pregnant. So this is a person who was fully aware and who had been informed. And then her own doctors ensured each time she came that she took a pregnancy test for the very reason.
With reference to these defendants, that's not true, Your Honor. The last pregnancy test that they administered was in December 3rd, which was 6 weeks into a 4-month prescription, knowing that within 28 days, the spina bifida is going to be irreversible.
On December 3rd, didn't Dr. Pastor give her the pregnancy test on December 3rd that was negative?
December 3rd,
and Dr.
that's
Wallace
correct.
on December 23rd?
December 3rd is the date that I have for the pregnancy
Dr.
test.
Pastor.
Yes, from Dr. Pastor, Your Honor. But I think that the main point with regard to the failure to monitor is that even if it was given, a test was given in December, the prescriptions were automatic refills that were going to extend for months. So unless there was a monitoring of her pregnancy status, they were playing Russian roulette with her health and the health of the unborn fetus because of the very real risk set forth by the FDA in the black box warning that if you get pregnant while you're taking VPA, you run a very substantial risk of a neural tube defect, which is precisely what happened here, Your Honor.
Thank you. Are there any further questions?
Thank
Thank
you.
you.
Your Honors.
Unless the court has any questions, I'll rest on my brief.
Thank you. Thank you both. Martinez versus the City of New York.
Good afternoon, Your Honors, and may it please the court. I'm Alan Rosinas. I represent the city respondents. As I promised during the calendar call, I'll keep it brief. I just want to address two discrete arguments that the appellant makes in his reply brief. First, on page 6, in support of his contention that we disagree with, that the city and the Board of Ed are the same entity, he quotes section 521 of the New York City Charter. And the quote he provides is, quote, "The title to all property, real and personal, for school or education purposes shall be vested in the city." Well, this omits the words that follow right after that in that section, which are, quote, "but under the care and control of the Board of Education." So that provision actually does the opposite of what he's suggesting it does. It suggests that the city and the board are separate, not the same. Second, Your Honors, we think that legal, as a matter of law, the entities are separate. He argues, and that's already in our brief, I don't need to get back into that, but he's arguing that alternatively, and we argue alternatively, if it is a factual issue, it's too fact intensive, and because it's not preserved, he can't raise it here. He argues that it's not fact intensive. Well, if you look at the provision, the 4-factor integrated employer test in 29 CFR 825.104, here are the 4 factors, Your Honors. Common management, interrelation between operations, centralized control of labor relations, and degree of common ownership and financial control. Now, particularly in light of the fact that these two entities are separate in at least many respects, we think in basically all respects for all intents and purposes, that shows that you're going to have to engage in this kind of a fact-intensive inquiry to figure out whether, even if there's an argument that for purposes of the FMLA, these are the same entity, you can't just go out, there's no simple way to do it, and the record is not going to support that inquiry here. So if there are no further questions, Your Honors, we ask that this court affirm.
Thank you.
Thank you.
NYU against Turner Construction.
Thank you, Your Honors. Canon Shanmugam Paul Weiss for Appellant Turner Construction. May it please the Court. This case would ordinarily consist of a breach of contract claim by New York University against Turner Construction. But because there was no damage to the actual construction site, and because the parties' contract included a waiver of all consequential damages, NYU included an additional plaintiff, the NYU Hospital Center, and brought gross negligence and negligence claims in an effort to recover more than—
Wasn't there a disputed issue of fact as to whether this work was extra contractual? It clearly wasn't part of building the building, which is what the contract was for. So why should the court make a determination as a matter of law that it did or did not arise out of the contract?
So, Justice Kern, we're happy to take the facts in the light most favorable to NYU. But our fundamental submission on the first issue, the question of gross negligence, is that there is a distinction as a matter of law between gross negligence and ordinary negligence. And this court, like the Court of Appeals, has repeatedly held as a matter of law that conduct doesn't rise to the level of gross negligence.
Well, let me ask you, because that really wasn't the question I was asking. The question I was asking was, one of the issues is whether there's a tort duty separate and apart from a contractual duty. So that was the question I was asking about.
Yes, and on that issue, Justice Kern, I think likewise we would say that as a matter of law here, first with regard to the university, our submission is that any tort claim here is impermissibly duplicative of a contract claim.
That's my question. Why is it duplicative where there's a real issue here, or there appears to be a factual issue as to whether the work that was done in preparation for the storm was done pursuant to the contract or not done pursuant to the contract?
There is a fact issue, Justice Kern, in the sense that we did not move for summary judgment on the contract claim. And so if this case were to go forward on the contract claim, there would obviously be a dispute about whether or not the contractual duties are breached. But on the question of duty, our submission is that when you apply the cases like dormitory authority, here the reason why the tort duty is duplicative of the contract duty is because the damages that are being sought on the claims are the same. The contract governs
What
both.
happens if it's ultimately found that these activities were not performed pursuant to the contract?
Well, it may ultimately be found that the contractual duties are not breached.
No, that's not my question. An argument could be made on this record that the duties that were performed were not performed pursuant to the contract to build the building, that they were extra contractual duties that Turner voluntarily assumed outside of the contract.
So
if that is a theory that the jury accepts, then it's going to be a tort claim and not necessarily a contractual claim.
So that is the submission that, as I understand it, NYU is making really with regard to the hospital center. In other words, the submission with regard to the hospital center
But why isn't that the same issue with the university?
So I think
ultimately it's not found to arise out of the contract.
So I think that for purposes of the university, the governing body of case law says you look to whether or not the facts underlying the contract and tort claims are the same and whether the damages are the same.
What about if it arises out of an independent duty?
So I think with—
Just to be clear, there is another agreement, right? The contract is separate, and then there's another agreement where they agreed to close over the hole over the airway.
So just to be clear, we don't think that there is that this could be understood as a case involving a separate agreement.
Well, that's a dispute. That's exactly what I'm asking about. Isn't that disputed?
No, I don't think that the university's submission here is that there is somehow a separate contract. Instead, I think at most their submission is that Turner independently, voluntarily assumed a duty outside the contract. Now, I think that they really do make this argument primarily with regard to the hospital center. And I think with regard to the hospital center, the question here, first of all, we certainly think that there is no evidence on this record.
I don't mean to harp on this point, but don't we have to decide that issue to decide whether the tort claim is duplicative of the contract claim?
I don't think so with regard to the university, but I think with regard to the hospital center, yes, you do, in the sense that we think that one reason why there was no voluntary assumption of a duty here is that there was simply no evidence that Turner assumed a voluntary duty outside the contract.
But
Again,
was it
there
part
are
of the
contractual-
contract? Was it part of the contract to do anything with regard to that hole?
No, there was no specific contractual duty relating to the air shaft.
And weren't they asked specifically, because the storm was coming, to address the issue with the air shaft in a particular way?
Well, it is certainly true that Turner was asked to address the issue with the air shaft, and the question is really whether Turner took sufficient steps to do so. And that's why we think this is at most a negligence claim rather than a gross negligence
Let
claim.
me ask you a question about that, because you keep coming back. Obviously, you want to discuss it, the gross negligence standard. My understanding of the law, it's reckless disregard. Why isn't there, again, a factual issue as to it was reckless if you accept the facts? They allege that it was reckless when they asked you to put plastic, Turner, to put plastic, plywood, and sandbags, and only partial sandbags were put down. Why wouldn't that raise an issue of fact as to whether that's reckless under the circumstances of this storm coming?
Justice Kern, it's because if the question here is whether we took sufficient steps, then that takes us outside the category of gross negligence, because we're a party.
But isn't that sufficiency a question of fact for the jury here?
No,
I think if you will, you took some facts. I think the court below said something about cheesecloth or something like that. You did something. But if that something was so far away from what needed to be done, from the request to put the plywood and put the plastic and put the sandbags, then there is an issue of fact there as to whether it rises to reckless, is there not?
No, I don't think so. And I would point the court to the cases on which we rely, cases like Kolnagi, Hartford Insurance, David Gutter, Furs, and the like, all of which are cases in which this court or the Court of Appeals has said, as a matter of law, certain conduct does not rise to the level of gross negligence. And again, just to be clear, we are happy to take the facts in the light most favorable to NYU here. Our fundamental submission, Justice Kern, is that under these circumstances, what NYU really wants the court to do, I would submit, is to sort of disaggregate sort of each step and say, by virtue of the fact that on their facts, Turner failed to take some particular step, that rises to the level of gross negligence. I think that's inconsistent with the cases, and if I could point the court to one
All
case.
the cases talk about a reckless disregard. That's a broad concept. Can you show that the conduct of Turner was reckless? And I don't know how that can be determined as a matter of law, whether or not the conduct, as we previously both discussed, was reckless.
Well, if that's true, Justice Kern, then I think that the court would have to effectively throw out all of the cases in which this court and other courts have determined this as a matter of law. And I would note further and parenthetically that if you take a look at the Goldstein case from the Second Department, that case essentially equates the reckless indifference formulation and the slight care formulation. And again, the fundamental problem and the reason why we think that at a minimum this court should knock the gross negligence claim out of the case is because, in essence, if this court were to say, this gets you to a jury on gross negligence, that really erodes the distinction between gross negligence and ordinary negligence. And if I could point this court to one case on this issue, it would be the Kolnagi case. Many of these cases arise in the context of alarm systems and security systems. That was a case where the Court of Appeals said that where an alarm company failed to arm a skylight and completely failed to arm the skylight, that that did not rise to the level of gross negligence. That's precisely the argument that is being made here by NYU, an argument that because we failed to take an additional step, in their view, erecting the plywood and the plastic, that we should therefore be held grossly negligent. And in a case like this, permitting that to go forward would essentially permit sophisticated parties to contracts to convert their claims not only into tort claims, but into claims for gross negligence. And so again, at a minimum, even if the court were to disagree with us on the duty issue, and again, we've made our submission on that point, we think that the court should eliminate the gross negligence claim and greatly streamline this case going forward. And I'm happy to rest on our briefs on the remaining issue of punitive damages. Our fundamental submission is that even if the gross negligence claim were to go forward, the standard for punitive damages is an even higher one, and it is not met here on the undisputed facts.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Ed Flanders. I represent the plaintiffs, respondents in this appeal.
Counsel, I'd like you to start with where opposing counsel left off with regard to the gross negligence. His view is that, this should not go to a jury. We should decide it here because on its facts, this is like the Kolnegi case.
Well, I think you need look no further than the Sommer case, really the seminal gross negligence case, where it's very similar here. The dispatcher was given an instruction to activate the system and deactivated the system. Here, Turner was given an explicit instruction. Use plywood, sandbags, plastic, seal up that opening, and inexplicably did not do that. I think that at a minimum, as the Court of Appeals held in Sommer, that raises an issue of fact for the fact finder to decide whether or not that reckless disregard of an explicit instruction, and by the way, there's no dispute that the instruction was given and understood by Turner. I would also direct this court's attention to its own decision in 87 Chambers. Similarly, the contractor was given a stop work order and ignored the stop work order. Turner, again, ignored the instruction to seal that opening, and if it had done that, would have prevented millions of gallons of water from entering into the NYU Medical Center and causing catastrophic
Had they done this before in other occasions, at the instructions of NYU to seal that exact same grate?
I didn't catch the first part, Your Honor.
They've done that before. I mean,
Oh, yes.
NYU instructed them before to do exactly what they instructed them on this occasion, and they had done it exactly as instructed in the past.
You're absolutely right, Justice Mendez. So in connection with Hurricane Irene, a year earlier, before the energy building project started, Turner was on site doing adjoining work, was asked to help out, sealed the MSB areaway using plywood, plastic sheeting, and sandbags, and it worked. So it's really inconceivable to me how it is that Turner thinks that ignoring an explicit direction when they know that the vulnerability of that areaway to flooding, and they want a determination as a matter of law.
I'm going to interrupt for a second just to circle around. What's your response to the argument that any tort claim by the university is duplicative of the breach of contract claim and should therefore be dismissed?
So they're clearly not duplicative, right? I mean, they keep trying to ignore the fact that an independent undertaking was given. There was a promise. Hospitals said, Turner, I need you to do this. Turner said, okay. They say that that's not part of the contract. We won't know that until after a trial, but at a minimum, that we have that an alternative theory that it is an assumption of duty. The Court of Appeals decision in Nayland makes it clear that that is a recognizable tort. And in addition to that, we're not seeking the same damages for breach of contract and our tort claim. We can't recover consequential damages, at least university cannot, NYU cannot recover consequential damages in light of the waiver unless it shows gross negligence. But it can, in fact, if it proves gross negligence, recover those consequential damages. So this is not a case like dormitory authority where the plaintiff is just simply trying to enforce and get the benefit of the bargain. We have an independent tort. At least there are serious issues of fact as to whether there's an independent tort, and we have different damages for each. And then I just wanted to respond briefly to the last point about punitive damages. The Court of Appeals, and I'm going to see if I can quickly find that, the site, but it's in our brief, has made it clear that punitive damages are available when there is reckless disregard or indifference to a plaintiff's rights. It does not require intentional conduct. So if there are any other questions, Your Honors, I am more than happy to respond. But I think at a minimum, as this court recognized in its questioning of Turner's counsel, there are serious issues of fact at a minimum, and that the gross negligence allegations and proof so far should go to the fact finder, and certainly serious disputed issues of fact as to whether or not there are duplicative claims, either an assumption of duty independent of the contract or subsumed by the contract, but those are issues of fact that need to go to the fact finder.
Thank you.
Thank you, Your Honors. Just 3 quick points on rebuttal. First, with regard to gross negligence, I would encourage the court to look at the cases that my friend Mr. Flanders cited, and in particular the Sommer case from the Court of Appeals, which was a case in which an alarm company completely ignored alarms for a 4-alarm fire. And the Court of Appeals, not surprisingly, said that that could constitute gross negligence. Again, by contrast, what's going on here is a claim of a failure to take an additional step. There's no dispute on this factual record that Turner took some steps.
I'm sorry, sir, but isn't the material point that your friend was making that it's not just that you used only one material of several that were recognized to prevent or ameliorate the flood? It was that we made a specific request that you do so, and that you had used these similar measures in the past and they had been successful. So it's sort of the synergy of you only used one material out of the several, along with we made a specific request that you use all of those materials, and that you had done so once in the past, and those efforts had been successful.
That's right, Justice Higgett, but what I would say is that when you take a look at the complaint, and I would point you to paragraph 63, the ultimate claim here is a claim that we failed to properly protect the air shaft. And so again, the claim here is that there was a separate request. There is a factual dispute about that, but again, I'm happy to take that at summary judgment as true. And our fundamental submission is simply that where you talk about not taking an incremental step, you're in the realm of ordinary negligence and taking reasonable care. I think with regard to the overlap in the duties, I think what I would say in response to Mr. Flanders is he referred to there being an independent promise, but the critical point is that that promise was still arising under the contract. And I would point the court to 2 contractual provisions, section 3.1 and section 3.8 JJ, at record 118 and 137. Those are the contractual duties at issue. And to be clear, we will make the argument at trial that those duties were not in fact breached. Those are very general contractual duties, but our submission is that those duties occupy the field here. There is no independent additional duty that was undertaken. And the last thing I would simply say is the fundamental problem with this case is that what NYU is trying to do is effectively turn Turner into the insurer here for all of the damage that took place at the NYU campus, damage that NYU was well aware could occur as a result of flooding, and further to make that argument in a circumstance where Turner was forbidden from closing the opening to the air shaft without the university's written approval. That's at R367. That's what this court should be concerned about. The risk that sophisticated parties are going to take contracts and really unsettle them by going forward with tort claims all the way up to gross negligence with punitive damages instead. And for that reason, we would submit that the Supreme Court's order should be reversed. Thank you.
Thank you.
Thank you. Thank you both. People versus Michael Walker. Just a minute. Just wait till council leaves, please. Thank you.
May it please the court, good afternoon. My name is Natalie Ray of the Legal Aid Society for Mr. Walker. I'll briefly address the appeal waiver as a threshold question. The question is whether, given the court's never corrected oral explanation that the plea was final, if my client waived his right to appeal, the waiver was invalid and unenforceable. We believe the answer is yes. The Court of Appeals has made it clear that an appeal waiver that suggests that a conviction is final is invalid and unenforceable. Here, the court did not merely suggest that it was final. It said so. It told my client, Mr. Walker, by giving up your right to appeal, you are giving up your right to argue that any errors took place during these proceedings in your case, or that any sentence in your case, no matter how long it is too long.
But there was a written waiver here. Does that written waiver not,
it doesn't,
didn't that clarify?
Well, it's in our view, it made it more confusing. First of all,
The written waiver made it more confusing?
yes. First of all, the court is, the oral, the statement I just made was made by the court. The waiver was discussed, the written waiver was discussed with counsel. So while the court says, by giving up, you're giving up your right to argue any error, then the written waiver says something completely different.
Well, let me just ask you, when the court asked the client to review, the defendant to review the written waiver, didn't he say, I'm going to let you and your attorney discuss it, and then they proceed to discuss it? So presumably the attorney is clarifying to the defendant what the judge has said and what the written waiver has said, and then he proceeds to say, have you finished? Yes, yes, yes.
But this can't be clarified. If on the one hand you say, you're giving this up, you can't raise any error, and then you say, but you can raise this error. You can raise the speedy trial. You're giving up this, says the court, all these errors. And then the written waiver says, but you're not giving up this. How can these things be reconciled? You're giving up everything, says the court. The written waiver says, oh, but you're keeping your right to a constitutional trial, et cetera, and then says, but you're giving up the review in the appellate division. The statements are incompatible with one another. Either if it's everything, or it isn't. There's no attempt to clarify these contradictions.
So if there was a problem in that regard, then why not raise it right there and give the judge an opportunity to clarify? Because presumably the judge isn't stuck with whatever he or she says at one moment. If they misspoke or stated something that was an ambiguity and that was pointed out to the judge at the time, then the judge could have clarified it on the record.
That did not happen, Your Honor. That's correct. But in the meantime, Mr. Walker waived something that's incomprehensible. And therefore, he waived something, we don't know what he knew. It can't be said that it's intelligent and knowing and voluntary, because it's impossible to reconcile these two. Assuming the court agrees with me, I will address the second issue, because this waiver should not be used to shield the obviously erroneous suppression ruling. The question here is whether the court erred in denying the motion to suppress, where the officer immediately pursued Mr. Walker based on without a level 3. And we believe the answer is yes. Pursuit requires a level 3 reasonable suspicion. In this case, there was no level 3. The facts are uncontroverted. The police officer has experience and training, no question. The Lincoln house is described as a drug-prone area, no question. The officer arrives, when he arrives, these two men are there. He hasn't seen them arrive, he hasn't seen anything. They're there, they could have been there 15 minutes before. He sees no object, uncontroverted, no money, no drugs, and then immediately jumps out of the car.
Well, after he sees them putting their hands together and
Yes, so
picking up, I know you're going to say it could have been M&Ms they were transferring to one another for Kittles or something like that. But the truth is that putting their hands together in that way, taking whatever they were taking.
But, Your Honor, the courts have said you have to see.
Given that there's also the drug, obviously, as you said, it's sort of a drug-infested area.
Your
Would
Honor,
that not be enough?
No, it's not enough. It's a
What
level
about that
two.
after the exchange, you call him the white male?
Yeah, walked away.
Walks quickly away.
But also what the officer says is my client stayed. All the officer had to do, Your Honor, is wait and watch a little longer. He had a right to inquire. He didn't have to leave. He could have stayed in his car and watched. He said, my client's conduct showed that he was waiting for his next client. Wait. I mean, it's every officer, but I'm sure the officer believed this was a drug transaction, but he just had to wait. Officers with training can't go around pursuing people without reasonable suspicion. I will keep whatever questions for that. Thank you.
Thank you.
Good afternoon, and may it please the court. Faith Petrolio for the people. This court should affirm defendant's conviction as the hearing court properly denied defendant's suppression motion. As an initial matter, defendant's appeal is foreclosed because he validly waived his right to appeal. But in any case, the hearing court properly decided that his suppression motion should be denied because the officer had probable cause to arrest defendant based on his observations from his car and on his training and experience.
I'm sorry, but with respect to the waiver, your friend said that there was a material disparity between what the judge said in the oral colloquy and then what was presented in the written waiver. What's your response to that? Is the presence of such a disparity sufficient to vitiate the waiver?
Your Honor, there wasn't necessarily a disparity between the two. In the oral colloquy, the judge was very clear in describing that the right to appeal is a separate and distinct right from the right to a trial, and went through all of the rights, including explaining what the right to appeal entailed. The waiver just took that colloquy and basically added a few details to it, such as the things that defendant was not waiving as a part of his waiver of appeal. So the officer had extensive training in this case. He also had extensive experience in this exact location, and that training and experience gave him the experience to correctly interpret the interaction that he observed. And the interaction that he observed was two men standing very close together. One had his hand out.
But couldn't it have been, as I said, that it was something innocuous that they were doing? I know we have cases where if you can't see it and you don't know what it is, you're really not supposed to go chasing someone without, seeing something, a glassine, some white powder. Otherwise, people could chase people for just what he was chased for here. Because most of these places where the police are surveilling are high drug areas.
Well, Your Honor, the officer didn't view defendant's actions in isolation. As you said, it was a high drug crime area, and he had a personal firsthand experience of that, as he had made other arrests for the sale of crack cocaine in that area. It was also late at night. It was about 1:30 in the morning. And he also was able to observe the two men's interaction after the hand-to-hand transaction, which was that the defendant stayed in the same location, the seller walked away very quickly, and there was no other social interaction that took place between them. And so based on that, he was able to determine that it was more probable than not that the defendant had engaged in a drug sale, and so he had probable cause to arrest him based on that.
What about your friend's point or suggestion that the officer should have waited a little bit longer to see if there was an additional similar type transaction that would have served to corroborate that what he had witnessed with these two gentlemen was in fact a narcotics transaction.
At the time, based on his observations in the car and given the surrounding circumstances, he had already had probable cause to arrest, and so he didn't need to wait for to see another transaction to have the probable cause to arrest. If there are no further questions, we ask that you affirm.
Thank you.
Thank you.
I'll be brief. The question on the waiver, we're not saying the court made it clear it was separate from the trial rights. There's no question. The problem is the scope that the court described that made it sound like you can never argue. You can't go to federal court. You can't go, no collateral proceedings. They didn't even limit it to appeals. And the people have no answer to that because these two explanations cannot be reconciled.
Counsel, I'd like to go back to the suppression hearing because we know all the circumstances. So can't one say that based upon everything that the police officer observed that evening, along with, the high crime area, can it be said that at that point he had reasonable suspicion that a drug transaction occurred, and then when he said police and defendant fled, that then raised it to probable cause?
Well, we would disagree. At the moment he got out of the car, he had seen a white man and a black man with hand gestures. No money, no object, no exchange, nothing. He had a level 2, I will grant him that. The facts, it's not what he believed, it's the facts he saw, what he saw. And what he saw just suggested, wait a second, and you wait till see something else. As far as him coming out of the car and yelling, screaming, I think the fundamental problem with the trial court's decision is the trial court did not understand or overlooked that the police officer ran. He's the one who ran screaming police. He didn't get out of the car, scream police, my client, and there's some different testimony that my client did not run immediately. But the problem is it's the police officer who engaged in this pursuit immediately in getting out of the car. Police officers cannot rely on their training and experience to go and pursue anybody anywhere in a drug-prone area. Thank you very much.
Thank you both. Torres versus Sanitation Salvage.
No, please. We are truly friends, by the way.
Okay, we treat you the same either way.
We do get along. It's nice.
Okay.
Good afternoon. David Engelscher from Queller Fisher and William Galina's office. And I'm here representing the plaintiff, who is the appellant today. It's the end of your day. I'm not going to take a lot of your time. I just want to focus on really what has come up several times in this case. On the record on page 8, Judge Armstrong wrote, here the defendant established a prima facie entitlement to judgment as a matter of law, dismissing the complaint by submitting a transcript of the plaintiff's deposition, which demonstrated that the plaintiff was unable to identify the cause of her fall. That is not true. That is not true.
So let's assume that she identified the cause of her fall as a sticky substance, residue type substance. Does that get her, what happens then with the fact that there was no notice and they cleaned the place? There's testimony that they cleaned the place between noon and 1 or 2 and 3. She even says, I went back and forth to the post office. There was the debris there, and then it wasn't there. So she even, concedes that, agrees with that.
Well, the problem is the court below ignored the testimony that customers regularly deposited their unwanted produce on the floor of the market. The market knew that. The market did nothing to
But
correct
it was regularly cleaned.
Well, now that's a question I think that a jury should answer and not the judge in the motion court below.
Why should a jury answer it when she, in fact, testified that it was clean and she didn't see anything, and it's undisputed that it was cleaned an hour before the accident?
Well, I don't think she testified it was clean. I think what she testified to was there were no solid pieces of the debris. And the residue here is, with the use of inference, can be that it came from the debris that was thrown there
Why isn't
constantly.
this like all our cases where if you can show you cleaned right before the accident occurred and there's no other evidence, that's it?
Well, again, there is testimony that came out about how it was cleaned. Shovels, brooms, rakes. Shovels, brooms, rakes do not clean up grease on the ground. They clean up the solids. So when she testified, I didn't see any solids, she didn't. She didn't. And by the way, there's no proof in this record that sanitation salvage came along and cleaned it up. All she said was, it was there when I left, it wasn't there when I came back. And when she was asked, did sanitation, I think so, or yes, but she didn't know that. There's no record, there's no schedule. There was nothing submitted in the motion court below. But the issue here was, because none of this conversation would matter if the judge looked at her testimony and said, because she said it, I fell because of the fruit and the residue. She didn't say, I don't know. She didn't say, I'm not sure. She didn't say, maybe, I don't know. When Mr. DeServi asked her, what caused you to fall? She said, I slipped on the residue from all the fruits and vegetables. Can't get any more clearer than that. Now, if somebody didn't believe that, that's an issue of fact. What the judge did below, with all due respect, was he resolved that issue of fact, which he's not supposed to do under Silman versus 20th Century. So I have nothing more to say on this issue. I'll wait to hear what Stephen has to say.
Thank you.
May it please the court, counsel. I'm going to be extremely brief. He raised in his motion papers the argument of a recurrent condition, and the reason why the argument of a recurrent condition doesn't work is the market was closed to customers. The business is designed to close at 1 o'clock to customers for sanitation salvage to come in and do their cleanup. So this cannot be a condition of a customer having dropped something at that location. The testimony has been unequivocal. From 1 to 2 o'clock, sanitation salvage comes in and cleans. The plaintiff testified that when she went to the post office, there was debris there. She came back, it was gone. Whether it was sanitation salvage, Hunt Point, or some other entity, it is undisputed this area was cleaned. And unless the court has questions for me, I will forfeit the rest of my time.
Thank you.
Thank you.
It's what wasn't said that's important here. Mr. DeServi did not say, he said it was cleaned, but I asked specifically, after this is picked up, is there sawdust thrown down? And the executive director of the market said no. So the fact that somebody picked up the solid piece of debris is meaningless.
But I don't, see, you're not addressing notice, though.
Well, no, it's...
How did this was, we don't even know, it might have been an hour here, not even. That doesn't give them enough time to be aware of a condition. You keep going back to recurring condition, but they were never told of that.
Excuse me, what the market knew of was that its customers regularly and ongoing way threw their unwanted produce on the ground and did nothing about it.
Well, sir, how do you respond to your friend's point, though, that it was the custom and practice to close the market at 1 o'clock for the purpose of cleaning the area, and so there wouldn't have been customers in that area or at that time?
It goes back to what I said earlier about how it was cleaned up. And that's an issue of fact. Can a rake pick up grease? Can a shovel pick up residue? Can a broom pick it up? I don't think so. So, and the fact that there was, by the way, no proof of anything on her pants when she walked out is good proof that she slipped on that grease that was there from the discarded produce earlier. I'm not saying this happened in that 1 hour that she left. This was there. And she even testified, by the way, that if she had seen the fruit on prior occasions, if she saw the solid produce, she would walk around it. This time she didn't see it and turned out to be just as dangerous. Just as dangerous. So it's what's not said here that's important. There's no proof in this record that sawdust was thrown. As a matter of fact, the executive director, Myra Gordon, said, we don't put sawdust down. Sanitation Salvage did not put sawdust down, or Absorbol or some other product that would help absorb the grease. So it's almost as if it was caused and created by failing to remove it properly, totally. And there's no proof in this record, Your Honors, that that the grease or the residue was removed. It was just the solid pieces that were swept, raked, or shoveled to be removed.
Thank you. Thank you both.
Please rise. Hear ye, hear. Orders to have the appellate division depart. This court is adjourned until tomorrow at 2 p.m. Please remain standing. Just in my head, I had switched this. I don't know if you noticed. These are like the back cushions. She's good. I mean, she's good with these. So.